Hello again, everyone. Welcome back for day 3 of our series on tort liability and risk management. I'm Kara with the Ohio LTAP Center, and I'm thrilled to be back with you all as your host. We've had a great couple of sessions so far, and we're ready to keep that momentum going today with our featured presenter, Ron Eck. Before we jump into the content, let's quickly run through our game plan for today's session to make sure everything runs smoothly. As Ron presents, please keep those questions coming in. Use the questions panel on your screen at any time. We'll be monitoring those and we'll address them either on the fly or during the final Q&A. If the audio drops or your screen freezes, just send a message to the chat panel. Our team is standing by to help you troubleshoot. If you want to follow along or take notes, you can find a PDF of today's slides right now in the handouts pane. And don't worry about missing a detail. We are recording today's session and we'll send that link out to everyone who registered. All right, that's the logistics covered. Let's get to the good stuff. Ron, I'll hand the floor over to you to get us started, so the virtual floor is yours.
Thanks, Kara. Thanks for that introduction. Welcome back, everyone. Welcome to day 3 or part 3 of tort liability and risk management. This is our final day. The previous 2 days we've talked about what tort liability is, a little bit about the tort process, from what the time a claim is filed to the jury trial, if one happens. We also yesterday looked at risk management, both from an organizational standpoint and from the standpoint of the individual employee. And through both days, we talked about a little bit about some common problem areas that may occur with design, maintenance, traffic control, pedestrians, and so forth. So does anyone have any questions on any of that material we talked about previously? Feel free to type that in the chat. And if anyone's doing that, there's a couple things that I thought about this morning that I haven't talked about or haven't addressed. So I'd like to take a few minutes at the start to do that. One is, on the first day, we talked about a number of different legal terms. And one I probably should have discussed is the burden of proof. I think maybe everyone's heard that term. I think there's movies or novels by that title. That basically refers to what is the burden of the plaintiff or the prosecutor in terms of producing evidence and witnesses and testimony and so forth in a case. And as many of you, maybe all of you, are probably aware, in a criminal matter, the burden of proof is beyond a reasonable doubt. So the prosecution in a criminal case must produce evidence and testimony and so forth that convinces the jury beyond a reasonable doubt that the person charged with the crime is guilty of that crime. And so if you imagine the scales of justice, beyond a reasonable doubt would mean one side of that scale of justice is really, heavily weighted with evidence and testimony, and so the scales are no longer equally balanced. But in a civil case, remember we talked about the civil versus the criminal division in the legal system. In a civil case, including tort claims, the burden of proof is by the preponderance of the evidence, or more likely than not, or 51% to 49%. So a plaintiff suing a road agency doesn't have to prove beyond a reasonable doubt that the road agency was negligent. All they have to do is convince the jury that it was more likely than not that the road agency was negligent. So I did want to bring that up because I think that's an important thing to keep in mind in some of these matters. The other thing I wanted to mention was I realized that probably my answer yesterday to the question about where would a deposition take place was not entirely complete, because I mentioned sort of physical locations where everybody's present in the room, if you will. But since the pandemic in 2020, of course, a lot of things take place virtually, like this very class that we're conducting this week. And so it is possible that a plaintiff's attorney requesting a deposition of a road employee that deposition may be done virtually by Zoom or Teams or WebEx or one of the platforms, the virtual platforms. So I did want to add that these days now there is also the possibility of giving a virtual deposition. So with that sort of background, and I don't know if any questions came in, Kara.
Thank you, Ron, for that background. And yes, we did have one question that came in. She's asking, does tort liability apply to only public agencies or to designers, private contractors, et cetera?
Yeah, great question. No, it applies to how much should I phrase it? Maybe the folks or the entities or the parties that public agencies would work with. For example, consulting firms or contractors. And in fact, in suits, it's not unusual where if it involves a construction project or something like that, where not only the public agency would be named as a defendant, but also say the consulting engineer. In fact, our first example, we'll look at that. Or it could be the contractor that built the project, or it could be maybe there's a traffic control device subcontractor on the project that provided the traffic control devices. All of those entities could be subject to a tort claim. And in fact, it applies to the private sector as well. For example, not a roadway case, but a big box store. If a customer, for example, slips and falls in the produce section of the food portion of the big box store, the joke was somebody slips on a banana peel or something like that, but those things do happen. That's a major kind of claim and risk that supermarkets and big box stores have to deal with. And so the same principles apply. The intricacies are a little different. For example, for a store, a big box store, they don't have to provide reasonably safe roads, but they do have to provide a reasonably safe store shopping experience. Their parking lot and their access drives and things need to be reasonably safe. So kind of the same principles apply both to private entities as to public entities. But good question. What I'd like to do today,
Ron, we have one more quick question.
Okay, great.
Sorry about that.
No worries.
So someone is asking for just a little bit more of a clarification for tort liability. Sorry about that. They want to double check and make sure that it's a type of a lawsuit. And then could ADA be another type of a lawsuit?
Yeah, good distinction, and that's correct. Tort claims involve, I guess, I'm not sure what the legal distinction would be, but it's a type of claim where the party that's filing the claim or the lawsuit has suffered some sort of injury or harm or property damage, or maybe a relative or spouse was fatally injured or something like that. But they're alleging there was some sort of harm and damage and injury that occurred, and they are seeking compensation from one or more parties that the plaintiff believes had a role in that accident or crash or incident that caused the harm or injury. So that's a tort. Remember, it's a civil wrong, or at least an alleged civil wrong where someone was harmed. An ADA lawsuit falls under the civil rights law, which is a different area of the law compared to a tort claim. And in a civil rights lawsuit, an ADA lawsuit, let's imagine a resident in your community can't get to work or can't get to the pharmacy because there's a tree has heaved up sidewalk slabs on the sidewalk, maybe near where they live. And so that has essentially, you might say, blocked the path or prevented someone, say in a wheelchair or using an assistive device, they can't access the sidewalk network. I think some actually civil rights claims may say because there's an obstruction or barrier that the city ignored or the city failed to maintain. And so in that case, the plaintiff who filed the civil rights lawsuit, they are not seeking compensation for an injury or anything. They would like the sidewalk to be repaired so that the barrier is removed so that they can get to work or get to the pharmacy or the library, or even if they just want to go around the block, whatever their transportation purpose is. And so they're seeking that to be remediated, not only for them, but of course for the rest of the general public, that sidewalk would be readily accessible. So that's kind of the difference and distinction between the two. But because they are kind of two different types of legal claims, if you will, that's why I use the informal term double whammy. It exposes a condition like that can expose the public entity to two different types of lawsuits.
Wonderful. Thank you, Ron, for that. That was the last of our questions to get started.
Okay, great. Thank you. I'll keep the questions coming. What we're going to do today is look at some case studies and see what lessons we can learn from actual lawsuits. I have a number of case studies we could talk about, way more than we have time for today. So what I did last night was I picked out a few that I think maybe are relevant to the audience. I looked at the roster of who all's been attending, and I thought about the questions and comments you all have asked over the past couple days, and I picked out a few case studies that I think would be relevant and maybe address some of the issues that some of you have raised. So let's just go through here. We'll see how far we can get in the time that we have, but I'll present kind of the facts of the case, what the legal theory of liability was. I'll be able to share some photographs and had the case gone to trial, the court exhibits that the parties were going to present to give you a feel for what kind of evidence both plaintiffs and defendant road agencies use in these cases if they go to trial. Then I'll share the outcome of the case, and then finally I'll kind of list lessons learned from each of the cases. In one of the cases, I think at least one, maybe more, I'll ask you for some input and get your thoughts on some questions I'll ask about the case. But don't limit your comments to that. Anytime you have a question or want to make a comment about something that I'm presenting or talking about in these case studies, feel free to put it in the chat, and Kara will interrupt me and we'll address those questions. These are in no particular order, but the first one I've selected here it's a case involving a pedestrian struck in a crosswalk by a motor vehicle. And let me give you some facts, and then I'll show you sort of the lay of the land of where this happened and kind of how it happened. But this case actually occurred on the campus of a large state university. So this is on a university campus. A female student, she was probably about 21 years old, I guess, had been taking evening classes, and she was returning to her apartment near campus after class. It was mid-November, about 10 p.m. It was raining, so it was kind of a chilly November night. She was dressed in a full-length kind of black winter coat, I guess you'd call it, or rain gear. And she was in the marked crosswalk. And while she was in that crosswalk, she was struck by a vehicle coming from her right. And the driver was a 75-year-old male. The only reason I mention that is because an older male driver like that is probably going to have poorer nighttime vision than a younger driver. She survived the crash, but she sustained very serious injuries. It was a traumatic brain injury that left her with cognitive impairments. In fact, apparently witnesses, or I shouldn't say witnesses, people, friends and family who knew her throughout her life said that she was an honors student at this university. She was active in community service. She did tutoring of other students. And so she had a bright future ahead of her. This was a life-changing injury. Apparently after this injury, she was the one that had to be tutored to be able to complete her studies, and certainly it affected her employment opportunities and that sort of thing. So given the life-altering nature of that injury, she filed several lawsuits actually seeking compensation, not only for her injuries, but for the sort of reduction in income or wages, if you will, over her working life, I guess we'll call it, because of the serious impact of this brain injury. So where did this all happen? This is not what the situation looked like when her incident occurred, but let me kind of orient you. I think you can see, this roadway roughly through the middle of the photo. It's a multi-lane, I'll call it arterial type roadway. I'll call this perimeter road because, this is under the jurisdiction of the university. It's a university roadway. But everything to the south or below perimeter road, this is the university campus. Everything above perimeter road here, this wooded area, you can see some homes. This is the local city or municipality. So she had been on campus and she had an apartment, it's not visible in this image, but somewhere up here. And so she was walking, as students would do, walking from campus to her apartment in the residential area or student housing area of the community. You can see the crosswalk here. As a traffic engineer, I look at that, and one thing that strikes me immediately is notice that crosswalk is skewed, as we call it. It's not at right angles to the roadway, and that's an issue because the shortest, quickest path across a roadway, of course, would be at right angles. That's the shortest distance. When you have a skewed crossing, it means the crossing distance is longer, and it may affect a pedestrian's ability to check for or judge oncoming vehicles or speeds of those vehicles. And then it's hard to see because these are pine trees, but I think you can see that there's a sidewalk under these pine trees that continues up into the residential area of the community. So I wanted to give you some history. This is what the intersection looked like originally. I think you can see it's a T intersection. The stem of the T is up here. And what was going on, and you can see it in this image, is the university is constructing a large parking structure. We can see a little bit of that here. And what's going to happen, and what did happen, is the exit roadway from that parking structure was going to come out here where my cursor is moving. And as part of that project, and this was obviously a joint effort between the city and the university, they are going to remove this road. This road will no longer exist, but it will still be a T intersection, but now the stem of the T will be down here. So traffic will come out of the parking structure and access perimeter road. This will not be a roadway anymore. And I think you can see that here. Obviously, this is a daytime Google aerial image, but this is kind of what the area looked like on the night of her incident. Notice you can see the parking structure here, a rather large structure. Here's the exit roadway, multi-lane from the parking structure. This roadway, the city street, has been removed. There's a new sidewalk here. The existing sidewalk under the pine trees is still there. The pine trees remain. And notice the crosswalk remains. And now this is a signalized intersection. It's hard to see the signal hardware, but this is a signalized intersection. And notice where the stop line is for this approach to the intersection. Notice that's a little bit unusual, right? We typically, a crosswalk is downstream of the stop line. In this case, the crosswalk is upstream of the stop line. It's almost like a mid-block crossing, and that's kind of the crux of the case. So the plaintiff alleged that that crosswalk design was defective in that it was located upstream of the stop line. And the complaint also said that that defective design and construction facilitated the crash and the injuries that resulted. So I'm kind of summarizing the complaint here, but I wanted to mention, if you remember, I guess on day one, we talked about the 4 things that the plaintiff has to prove to get their case to the courtroom. And one of those was that the breach of the duty, the failure to follow the standard of care, was a direct cause of the crash. And so in their complaint, and remember, a complaint is just allegations. The plaintiff has to prove those allegations in the courtroom. But they're alleging that the defective design of that crosswalk facilitated the crash and was a cause of the injuries. Here's many of you recognize this. These are just scanned pages from the manual and uniform traffic control devices. This was going to be one of the plaintiff's trial exhibits at trial, and they were going to show a couple things. Number one, they were showing that, of course, as I said, the best practice in crosswalk design is the crosswalk should be at right angles to the roadway being crossed. But also notice in all these examples and others in the MUTCD, of course, the crosswalk is downstream of the stop line, not upstream of the stop line. The defendants, the 3 parties that were sued in this case, were the consulting engineering firm, we'll call them the designers, that designed. They really did everything in this area. They designed the parking structure, they designed the road system, they designed the new sidewalks on the opposite side of the street where the old road had been. Also, the general contractor was sued, and I'll call them the builders, and they kind of built everything too. They built the parking structure, they built the roadway, they removed the existing roadway that I mentioned, they built the sidewalks, probably had a subcontractor come in to install the traffic signal hardware, but basically the builders did everything. And then I mentioned this was a state university, and so the state was sued, being that they were kind of the owner of the project, or the owner of the property, if you will. So no local road agency was involved in this particular case. Although I was sort of surprised that they didn't sue the road agency sue the local community or municipality, because they did have a hand in everything that went on here as I described to you. Also notice the motorist, the driver of the car, is not listed here, and that is because soon after this crash occurred, the driver's insurance company offered the policy limits, and so they paid those policy limits, and they were not a party to the suit. And if you just think about it and think about what we talked about on day one, compared to these entities, probably the motorist is not going to be a deep pocket. These are probably the deep pockets that the plaintiff's attorney would be seeking to get some compensation. They went through the discovery process, as we talked about on day one. Quite a bit of information was generated. I'm not going to obviously share all of that with you, but there were some photographs. I'll show you a few more photos. There were design drawings, of course, of a project of this magnitude. There's going to be many pages of plans and drawings. There were some marked up drawings where reviewers had made comments about the proposed design, and I'll share one of those with you. And then, of course, there was a variety of deposition testimony of various parties involved. This is just one of many plan sheets that shows the original design. And to orient you, know the parking structure is down here, come off the bottom of the image. This is the new exit roadway from the parking structure that intersects perimeter roadway. This is the sidewalk under the pine trees. Notice this road has been removed. A new sidewalk installed here. Stop line here. This drawing doesn't show the traffic signal hardware or where the signal indications are. That would be in another drawing. But as I said, this is a signalized intersection. But of course, the main issue, the crosswalk, remains at the same location as it was originally. I mentioned there were also some marked up drawings. So notice here's some marked up drawings with a marked up drawing with reviewers' comments. So let's blow that up so you can read it. And it's addressed to Gary, who I guess was one of the designers. It says, Gary, if the ramp has not been poured, we would like to move the ramp to the west so that we can slide the stop bar a bit back and have the crosswalk in front of the stop bar. The crosswalk would extend straight north and tie into the new proposed crosswalk. So this is what the reviewer was proposing, that they take this out and put the crosswalk here, which I think we would all agree makes sense and really how it should be. Not only is it a right angle crossing, but it's downstream of the stop line, which is what the design practice would recommend, or design guidelines would recommend. So one of the big things in this case, and of course this is not unusual, right, to have reviewers make comments or red lines on plans and drawings, but one of the issues with this case is that no one ever produced a written response from Gary. And if, in my mind, if someone makes a written review comment, whether it's on a set of plans or about a report or whatever it might be, that comment deserves a response. Even if the response is, I don't agree with your comment, we're not going to change it, there should be in the record some sort of written, written response. In this case, there was no written response. In deposition, Gary said he produced a response. He provided a written response, but it could never be, there was no evidence of it. So in fact, the judge in a pretrial motion said that he would allow the jury or he would tell the jury that if there's no written evidence of Gary's response, the jury can assume that Gary didn't respond. So that was kind of not a good thing, obviously, for the defendants. Here are some other photographs.
Ron.
Yes.
Hi there. Sorry, we have a quick question.
Sure.
This person is asking, what are the normal personal policy limits, and do you have to disclose those during deposition?
Oh, great question. And I don't know that there is a normal. It can range all over the place. And that would actually probably be disclosed early on in the case. If you remember, I think on the first day we talked about interrogatories, which are written questions raised by one party and answered in writing under oath by another party. That would typically be one of kind of the first interrogatories that would be given to defendants in lawsuits. And it would probably say something like, what are the policy limits? And then it might also say, please attach a copy of your policy or something like that. So that would be something that would probably be known even before depositions would be taken. That would be handled during the request for production of documents or during the interrogatory portion of the discovery, which usually happens kind of early on, even before depositions have been taken. Thanks for that question.
Wonderful. Thank you so much. We don't have any more questions.
Okay. So this is obviously a daytime view, not nighttime, but this shows the crosswalk in question. We see a pedestrian here. He's walking in the same direction that she would have been heading. Witnesses who were also walking that night on the sidewalk said that she was probably a step or two ahead of where this fellow is. So she was more or less in the middle of the lane, and the vehicle that struck her was coming from from her right. And just to get into a little bit of, kind of the strategies and the tactics, of course, in a case like this, we talked about how the defendants will want to show that there was negligence or unreasonable behavior on the part of the pedestrian. And so they brought up the issue of, it's a rainy night in November. Why are you wearing a full-length black coat? You should have realized that drivers have a hard time seeing someone in black in the nighttime environment. They argued that she should have had some retroreflectivity on her shoes or on her backpack, or had a wristband that was reflective, those kinds of things. Had the case gone to trial, they would have tried to show that she was not a reasonable pedestrian. They also raised the issue. They said, you have a 75-year-old driver coming at you, you're dressed in black, he's going to have a hard time seeing you, but you should have been able to see the headlights on his vehicle hundreds of feet away. So you had the opportunity to either run across the street or wait at the center line. You had a chance to avoid the crash. So again, they were trying to kind of pin some responsibility for this incident on the plaintiff. This is kind of a driver's perspective of the intersection. You'll notice you can see the crosswalk here, and there is signing for the crosswalk. But notice you can't really see the stop line, because if you look closely about where my cursor is, you can see there's a little crest or hump in the roadway, and that stop line is on the other side of that hump. So it's kind of hard to see the stop line, but you can see the signals. And another thing you probably notice there's street lights in the area, a number of street lights. And in fact, I mentioned that this is a university roadway. The university is responsible for the maintenance and operation of this roadway. So it was the university police that responded to the 911 call about this crash. And the officer who responded to the scene, she said the first thing she noticed was that the intersection was very well lit. And she's testified in deposition that after she made sure the victim was being tended to by the paramedics, and after she had controlled traffic in the area, the first thing she did was take a photograph, because she wanted to show how well lit the intersection was. So here is this is the photograph she took probably within an hour after the crash occurred. And would you agree with me that that really doesn't show a well-lit intersection? And I'm not criticizing her. To me, we should take photographs. Usually the more photographs, the better in trying to defend a case. But in this particular instance, this photograph actually worked against the defendants. In fact, the plaintiff adopted this photo as one of the exhibits that it was going to show to the jury in the trial or in the courtroom. The other thing, and I don't want to sound like I'm beating up on her, because I'm not, but the other thing is that if you're going to take nighttime photos, don't use a flash. I mean, it could be argued that photos generally don't replicate the human eye, what the human eye sees, but certainly a flash photo at night definitely doesn't replicate what the human eye sees. So in hindsight, she probably shouldn't have taken a flash photo, but like I said, to me, she did the right thing by taking a photograph. It's just that in this instance, it didn't work out to the benefit of the defendants. But notice in the photo, you can't really even see the crosswalk markings. I'm not sure if that's due to retroreflectivity issue with the marking, or you can also see there's a lot of, because the pavement is wet, there's a lot of reflection, and you're seeing other lights and things in the kind of the water puddles on the surface. This case did not go to trial. There was a confidential out-of-court settlement reached with all parties, and my estimate is that it was on the order of about $2.5 million. A couple things I should tell you. One thing, in this particular state, awards against state agencies are capped at $100,000. And we didn't talk about that on day one when we talked about the Tort Claims Act. But another thing that is in some states' Tort Claims Act, not every state has these caps, but some states have what they call caps, or maximum amounts on the awards that can be made against government agencies. And in this particular state, their Tort Claims Act dates back to, I think, 1973. And at that time, of course, $100,000 was quite a bit of money. I mean, it still is, but in the current world that we live in, I mean, I think I've been told that $100,000 might not even cover one day in an intensive care unit in the hospital. So those sort of things have changed over time. So the state was aware that this was a real serious case, had a high sympathy value, and so fairly early on, they offered their $100,000. So what's that, 0.1 million? Also, as the case went on, the contractor, the builder, filed a motion for summary judgment. Remember, that's a motion to the judge to dismiss the case. And their argument was, Your Honor, we are builders. We build what people tell us to do or ask us to do. We don't have structural engineers on our staff. We don't have traffic engineers to analyze each design that we're asked to build. We assume that the owner and the designers have done a reasonable job of designing the structures or the intersections or whatever it might be. And in my experience over the years has been, in most cases, judges are sympathetic to that and will dismiss the contractor from the case. But in this case, it was interesting. The judge in his motion, or his brief, I guess they call it, brief denying the motion, he denied that motion for summary judgment. And he said, you know, I'm an attorney. I have an undergraduate degree in political science. I went to law school. I practiced law for 20 years. Now I'm a judge. I have no background in construction or design or engineering. He said, but even I can see that that intersection is crazy. That's not how you design an intersection, and that's not how you locate a crosswalk. So even though you don't have designers on your staff, somebody on the contractor staff should have seen that and raised a question about it. That was basically the judge's thinking. And so the judge didn't let them out of the case. And I think at that point, the parties reached a settlement. My estimate is, of course, as I mentioned, that about 0.1 million of that would be the state's share. But I suspect the contractor and the designer, the consulting firm, I suspect their shares were about 1.2 million each, roughly. So that would add up to, I think, 2.5 if I did my math right. So if you go there today, if you go to this college campus today, this is what it looks like. The parking garage is down here. The crosswalk now is here, where the reviewer had suggested it be located. And notice the sidewalk under the pine trees is no longer there. They have like a zigzag sidewalk that leads to the new location of the crosswalk. And there is kind of a rest of the story to this. A couple years ago, I was teaching this class in person in the state where this campus, university campus is. And one of the people in the class, and it was in October, I think I was teaching my class. One of the people in the class said, "Hey, I know where that is. Our daughter started school there in August, and so my wife and I took her to this location, to get her set up in the residence hall and whatever, parents activities taking place at orientation and that sort of stuff that happens at university campuses." And so he said, "I've been through there several times." He said, "You know what I saw?" He said, "Students were crossing here. In fact, if you look real closely, I think you can still see some of the paint that didn't get removed for the crosswalk. But that is probably the shortest path for students. And so they apparently are still continuing to cross there, even though I would argue it's not a safe location. But I think it also shows we need to think about human behavior and maybe what they should do. Maybe the city and university, again, work together, but maybe put in some type of fencing or barricade there, or a big grass knoll or something that would make it difficult, if not impossible, for students to cross here and kind of force them to the crosswalk location. But anyway, that's that case study. What lessons might we learn from that? I think one, of course, is to make sure we follow accepted design practices and criteria. I'm not sure what really happened there, why that sort of backward location of the crosswalk and the stop line was allowed to be installed like that, even after a reviewer commented negatively about it. But it is important, of course, to follow current design criteria and if we're not consistent with the guidelines, at least have a design exception or something like that to document why you're deviating from the criteria. But in this case, there was no design exception. In fact, the designer, Gary, never even responded to a reviewer's comment. And I think in the courtroom that would have reflected negatively certainly on the consulting engineering staff. Make sure you document your work, kind of related to that, why you did something or why you didn't. That relates to what we just talked about. And then, as I mentioned, don't ignore human behavior. Humans, we are all kind of energy minimization creatures. We like to take the shortest, flattest path between 2 points. And we shouldn't ignore that in our designs. So that was the pedestrian example. If anyone has any questions or want to make comments on that, feel free to do that. I'll maybe pause a minute or so here if any questions come in.
Yeah, thank you, Ron. We do have a question. They're asking, should a defendant only represent their side in a positive light, even if they believe there is culpability on their part?
Obviously, it's going to depend again on the situation, but I would say generally, yeah, the defendants want to point out the strong points, the things that are in their favor, even if there is, some serious, say, issue or maybe not complying with a design criteria. Or in this case, I don't think it really, personally, I don't think it would have held up too well in the courtroom. But in this case, the defendants were trying to, as I sort of described, were trying to pin responsibility on the plaintiff for not, wearing dark clothing at night, not having any reflective material on her. Also, the question of, why didn't she, seems like their argument was she had a chance to avoid the crash because she should have seen the oncoming headlights well before the time that the driver could have seen her. So related to the question that just came in, that's another tactic that the defendants can use, is maybe not only point out the positive things they did, but try to pin responsibility on the plaintiff for things that they failed to do or show that they were not being reasonable as a pedestrian. It didn't happen in this case. I'm not suggesting that it did, but another thing that sometimes happens in pedestrian cases, and you all know this too, especially in college towns, is that maybe she was on, and she wasn't in this case, but maybe the pedestrian was on a device, you know, they were looking down, they weren't even looking up or kind of aware of their surroundings, and that would be another approach that the defendants could take to kind of pin responsibility on the plaintiff, or at least contributory sort of responsibility. But again, remember from day one, I guess, if the plaintiff or if the defendant can show that the plaintiff was 51% or more responsible, the plaintiff doesn't collect anything. So that's another tactic that would be used, would be try to, you know, show as many issues that the plaintiff had in terms of responsibility, whether it was their dress or what they were doing or they were distracted, they failed to respond, those sorts of things. Any other questions?
No, Ron, thank you so much for that answer. That's all for now.
Okay, thanks.
Mhm.
Thanks for the questions on that. So let's shift gears a little bit now. This is a higher type road, and this is a temporary traffic control device issue. But here are some facts, and then I'll show you some photographs of the area. This was a motor vehicle crash, a single vehicle motor vehicle crash that occurred about 8 a.m. in early March. It was sunny, a sunny, dry morning. The roadway is a 4-lane limited access divided highway near an interchange. Posted speed limit 65 miles per hour. The contractor alleges that they were setting up temporary traffic control on the northbound roadway. A section of the left lane was closed so that an emergency turnaround in the median could be removed. And at the time of the incident, the taper and the arrow board had been installed. So here's an aerial view of the area. You can see this, it's not an interstate, but it's a limited access roadway, speed limit 65 miles per hour. Here's the interchange I was mentioning. And probably earlier, or I should say the previous year, this happened in March. The previous year, this roadway south of the interchange had, or actually for a couple years, had undergone major reconstruction. In fact, it was one lane of travel in each direction for a couple years while they rebuilt the road essentially. And so that's why this is the turnaround or the crossover that was being removed. This was a crossover that had been installed for the construction project, I guess to allow the contractors to move between the two roadways, also probably to allow emergency vehicle access. But now that this long-term project was completed, the contract called for this crossover to be removed. And so that's what this crew, was a small crew, was working for the contractor that morning to remove that crossover as required by the contract. And you can see where the taper started, and notice you can see where the on-ramp, because it might be said a vehicle coming from the ramp onto the freeway maybe might be said precipitated this whole sequence of events. But on the main highway was a single unit dump truck that was carrying stone, and he was headed north toward the top of that image in the left lane, and an automobile was entering the highway from that on-ramp that I showed you. There was, he claimed, or he testified in deposition, that there was no temporary traffic control on the ramp to indicate that there was construction on the main line of the roadway. And that, his testimony was confirmed by the investigating state police officer, who also said there was no temporary traffic control on the ramp. So as that automobile merged into the right lane, the driver apparently moved into the left lane in front of the dump truck. But then the automobile driver, who claimed he didn't know work was taking place, or there was a lane closure, stopped suddenly because of the line of traffic at the lane closure. And when he stopped suddenly, that caused the truck driver to swerve into the grass median. It traveled in and out of the median for a while and finally rolled onto its passenger side in the middle of the left lane. And in that incident, the truck driver suffered a serious spinal cord injury and so filed suit against the contractor. And here you see the truck at final rest. It had been loaded with stone, crushed stone, ended up on its side, and you can see that the load of stone was basically dumped onto the roadway. So it was a single vehicle crash. The driver also filed a suit against the driver who entered from the ramp, but I think they resolved that matter early on. So the main case was against the contractor. They took depositions. The truck driver stated there were no signs warning of road work ahead or of the lane closure. So apparently no warning signs on the main line or on the ramp. The investigating police officer stated, quote, state requirements regarding advanced warning signs for work zones were not followed. The work zone was still being set up. So they were still setting up the work zone. It was not completely set up at the time, but it sounds like they set up the taper and the work area first rather than setting up the warning devices first. So here's a scene photograph. I think in the distance, the truck is on its side. But notice here's the taper. The taper starts here, and back here where the arrow is, you can see the back, or you can see the arrow board, I should say, the arrow board. The ramp would be off to the lower left, or lower right. And interestingly, and this is not unusual that this sort of thing happens, but this was not the tire mark from the truck driver, or actually from anybody involved in this incident. This apparently was from a previous incident. This mark here in the distance next to that black pickup truck, that was a mark apparently made by the dump truck driver as he had braked and was swerving into the median. But notice the arrow board is back here rather than at the start of the taper. The plaintiff's analysis was that this state's temporary traffic control manual requires advanced warning signs be set up first, and it appeared that in this case they were not, followed by the taper and then the channelization for the work area. So it sounded like this crew set this up backwards. They set up the taper and then the channelization for the work area, but they set up the advanced warning last, or actually it didn't get set up in this case. They were going to set it up last. The state's temporary traffic control manual's typical application calls for the arrow board to be located at the start of the taper, not at the end of the taper. So the plaintiff alleged that the temporary traffic control setup did not comply with the relevant criteria. There was no advance warning for the driver. The arrow board was not conspicuous, and also apparently the taper was too short. And the plaintiff, this was going to be one of their trial exhibits. This is the typical application from this state's temporary traffic control manual, which is based on the MUTCD. But notice, I think you can see the taper here for the lane closure, and notice the arrow board is at the start of the taper, whereas what actually happened in this case was the arrow board was here at the end of the taper. And these advanced warning signs had not yet been installed. Some additional information. The state's temporary traffic control manual requires that lane closures with tapers and arrow boards must be installed by certified traffic control supervisors. And it was learned during discovery that the foreman who was in charge of this crew was actually a concrete specialist and was not a certified traffic control supervisor. So that was not in compliance with the state's temporary traffic control manual. And in fact, the supervisor or the foreman in deposition testified that he had never installed a lane closure prior to this date. This was his first time that he had ever set up a lane closure. The parties settled this matter shortly before trial for a confidential amount. I'm not aware of what that was. My guess is it was probably in the area of $250,000 or so, I suspect. So what can we learn from this? Well, for one thing, make sure the work zone personnel are appropriately trained and certified for the traffic control work they are doing. In this case, the state's manual specifically required that a traffic control supervisor do this work, and the foreman who was in charge of this crew was not certified as a traffic control supervisor. The other thing that I haven't mentioned, but you saw that this happened about 8 in the morning. There was a state DOT inspector assigned to this job. He had just not arrived yet. He arrived shortly after the crash occurred. But my thinking is that the crew, especially since they had never installed a lane closure before they started work, they really should have waited until the state inspector was on the job and could have given them some guidance. But to minimize erratic maneuvers by drivers, make sure the advanced warning devices are in place and the devices and channelization are correctly installed. And in this case, I think the taper was too short, but probably more significantly, the arrow board was not placed at the proper location and there was no advance warning. So this overall, this was not a good situation. But any questions or comments anyone has on that example?
Thank you, Ron. We actually do have a question that kind of came in right after we finished with the questions from the previous example. So, but I feel like this could also kind of go along with the theme.
Sure.
The person was asking if it's possible that part of the settlement could be that the design must be changed and rebuilt.
That's a great question, and yeah, that can happen. I won't say it always happens, but sometimes that is what a plaintiff may kind of make a request. Now, legally, I'm not sure what that's called or how that's handled, but yeah, I have actually been involved in some cases where I can think of 2 fatal crashes that involve more of the roadway design rather than traffic control. And in those 2 cases, I think it was young people that sadly were killed, but the parents, as kind of part of the settlement, it never went to trial, but as part of the settlement, the parents asked, could the road agency correct the design? And I forget what the details were, but say it's something like this. The settlement would say that the road agency, or in this case, I guess the university, would relocate the crosswalk to the proper location. So yeah, that there is, I think, precedent for that. I'm not sure what that's called, what the legal term might be, but in settlements, that can be something that can be part of the settlement, certainly. Yeah, thanks for mentioning that or raising that.
Thank you, Ron, for that answer. And that was all the questions we have for now.
Okay, great, thanks.
Mm-hmm.
Now let's look at number 3, case number 3 here. And for this one, I'll ask for some of your input after I present it. So I'm going to try to maybe, I hope I'm successful, I'm going to try to avoid giving my personal opinions on this until I present my questions to you all. But I call this sweeping mud from the road. I'll only be a few minutes. This is actually a sad case, I think, but a motorcycle struck the rear of a rubber tracked skid steer with a broom attachment that was sweeping mud off of a state roadway. And the motorcycle operator was fatally injured in the crash. So it was a two-lane, two-way rural road. Skid steer was, say, going north, and the motorcycle was also going north. There was a sweeping the mud created kind of a cloud of dust, and apparently the motorcycle operator didn't see the skid steer and struck the back of it and was fatally injured. This happened, you can see, it's kind of mid-afternoon in October. It was a bright, sunny fall day. The weather was not an issue. The roadway is straight and level, as you will see. Posted speed limit was 45 miles per hour. And these are some scene photographs. But I should notice in this scene, the skid steer is moving away from us. Actually, both the motorcycle and the skid steer were coming toward us at the time of this incident. The skid steer operator claimed he never knew that something had struck him. He didn't feel it or didn't hear it, and so he continued straight ahead, coming toward us or toward the front of this photo. But apparently, at about the time of impact, this vehicle was driving in the opposite direction. So it would have been going south, let's say. And in this vehicle was an 18-year-old high school student with his younger sister, and they were driving back home from school. It was the end of the school day. And they witnessed what happened. And when they saw that the skid steer operator just continued to proceed forward northbound, they tried to flag him down and let him know that there'd just been a serious incident. And so I think you can see here, the skid steer operator did a 180 to head back to the crash scene. So again, I want to emphasize at the time of the incident, the skid steer and the motorcycle were heading toward us, toward the front of this photo. Here's another photo, a more close-up. I think obviously the victim has been transported to the hospital, but you can see the bike motorcycle has been put upright here. This is the skid steer. Similar, I guess, to the first case study. I want to point out these are not lights on this skid steer. In fact, notice there are no lights or anything on the skid steer, but I think you can see this is in the shadows. It's getting to be late afternoon, and I'm pretty sure the investigating state police officer who took the photograph probably also used a flash attachment. So what you're seeing is the reflection from strips of yellow reflective tape that are on the back of the skid steer. So those are not lights, they're just reflective tape. Here you see the state police photo of the unit itself, the skid steer with the attached broom. Here you see the motorcycle. It was laid down on its side after the impact, but it was, you can see, put back up on its wheels, probably for photographic purposes. One thing you'll note, I think, especially those of you who are motorcycle operators, notice that that front fork has been compressed severely because this bike ran into the back of that skid steer. And they're in crash reconstruction, in the field of crash reconstruction, there are equations or curves or tables that if you know the amount of compression of the fork here and you know something about the stiffness of the bike, meaning the make and model of the motorcycle, you can estimate the impact speed of the bike at the time it struck whatever object it ran into. And so in this case, not to get ahead of things, but in this case, one of the defendants in the case retained the services of a crash reconstructionist, and that reconstructionist measured the fork deformation, and using appropriate techniques or formulas was able to estimate the speed of the bike at impact, and it was estimated to be around 40 miles per hour, 38 to 42 miles per hour speed at impact. Few more facts. The police report noted that the sweeping operation created a cloud of dust that visually obstructed the roadway. That was in the narrative portion of the police report. And that was consistent with what the student, the 18-year-old male who was driving, and his sister, that was consistent with what they said as well. They said there was a cloud of dust that obstructed the roadway. The crash was adjacent to the access road serving the pad for a recently developed natural gas well. And it was just I'll call it a dirt road, an earth road, unpaved road that served the well pad and connected the well pad with the state highway. There were no warning signs present. There was no shadow vehicle. And I think I showed you there were no functioning lights on the skid steer. Here's a few more scene photographs. This is kind of opposite direction of what I just showed you. Remember, both the bike and the skid steer were headed away from us at the time of this incident. But notice, I guess the state police officer maybe took these to show you. You can say by this time the dust settled, because this is probably maybe an hour or more after the crash now. But notice you can still see kind of that, you can see where kind of that silvery kind of appearance where apparently the dust has settled on the vegetation. This is the access road, but this is after a subsequent remedial measure. Remember, we talked about that on day one. After the crash, the company involved with the gas well placed stone, crushed stone here at the throat of the access road. And actually the driveway permit required that this should have been present after the road was constructed, but it was not. And so after the crash, the stone was put down, and that's why I call it a subsequent remedial measure. And the road would be kind of off to the left here. So you can see kind of the wheel tracks of vehicles leaving the well pad would track some mud onto the state roadway. And in fact, here's one of the vehicles. You can see kind of a clod of mud here. But also, if you look at the vehicle that I guess had been at the well pad, you can see its tires are covered with mud. There's kind of mud in the wheel wells here. And so obviously mud had accumulated onto the roadway surface, and that's why the skid steer was sweeping the roadway. There were 3 defendants. I'll call the one the energy company, and that's a fictitious name. I learned after I named this, I think there is an actual company called the energy company, but I'm not referring to them. This was my fictitious name, hopefully fictitious name, for the company that developed the gas well, the well pad, the access road. Excuse me, that was sort of their involvement in this scenario. And then we have, I'll call the contractor. It was a very small company, but they actually prepared the well pad. They cleared the vegetation, they leveled the well pad, and they built and maintained the access road. And they also, under contract with the energy company, they also swept the state road. And the state DOT is involved because they issued the driveway permit for the access road. So those are the 3 defendants. The plaintiff alleges the energy company failed to comply with the driveway permit in failing to inspect the roadway and not maintaining a reasonably safe state road, which the driveway permit required that they do. The contractor, the plaintiff alleges, created a dangerous roadway condition by sweeping the roadway with no warning signs, no lights, no other protection in violation of state and industry criteria. And they said the state DOT failed to enforce the driveway permit that it had issued. So of course they had the discovery process. A lot of photographs were produced. I've shared some of those with you. The driveway permit was produced. That was something that would be under the request for production of documents. And so probably the state and the energy company would produce the driveway permit. And then there was quite a bit of deposition testimony. The driveway permit was issued to the energy company in May of that year. Remember, this crash happened in October. It called for them to keep the surface of the state road clear of mud and to follow the state's temporary traffic control manual, which governed the short-term work like that, or mobile work, I guess you'd call that, with the skid steer on the roadway. The access road to the well pad was built in June, so about a month after the driveway permit was issued. And October 4th, which is the date of the crash, that was the first time the state road had been swept. There was quite a bit of deposition testimony. The energy company representative testified that he was not aware of this permit, although he was aware of permits for 13 other access roads. As some of you may be aware, I know there's gas development in Northeast Ohio, of course, so you all are probably familiar with this, but usually there's a number of well pads in the area, each having access roads serving them. And so that's why apparently this representative kind of was in charge of like 14 of those driveway permits. He noted that no one in the firm makes sure employees or contractors observe the provisions of the permit. And he was a manager or an administrator. He admitted he had no engineering or construction knowledge, but he stated that he had heard that if you're sweeping a road for 15 minutes, you don't need any traffic control. So that was his testimony. The contractor testified that the skid steer operated at 3 miles per hour on a 45-mile-per-hour roadway. He testified that he had never worked on a public roadway before. This was the first time they had worked on a public roadway. He said he would use traffic control only when, quote, there's a lot of traffic. That was his testimony. And he stated that, quote, a 45-mile-per-hour road would never require traffic control. And if you are only there for 15 minutes, you don't need traffic control. Those were his words. And he denied being familiar with temporary traffic control guidelines. He had never heard of the MUTCD, and he admitted he had never heard of or seen this state's temporary traffic control guidelines. An additional note, in this jurisdiction, meaning in this state, the state law in the state motor vehicle code says that all mobile equipment designed to be operated at 25 miles per hour or less, quote, shall display a slow-moving vehicle emblem. So I'd like for you all maybe to kind of play the role of a jury, but before we get to that, I have a few questions for you, and you can just type your response in the chat, and Kara will just call out some sample responses. So my first question is, and this is just yes or no, you can put Y or N in the chat, but do these claims by the plaintiff, do you think they satisfy the 4 elements for a case to reach the courtroom? And just to review, the plaintiff has to show that the defendant had a duty to the plaintiff, that there was harm, that the defendant breached the duty or failed to follow the standard of care, and fourth, that failure to follow the standard of care was a direct cause of the incident or the crash. So do you think, yes or no, do you think these claims satisfy the 4 elements for a case to reach the jury? Just type
We
that in the chat.
have,
Kara will just call
yeah,
out a kind of a representative sample of the responses.
yes, we have an overwhelming agreement that yes, um, those absolutely satisfy those elements to go to trial. And we've got lots of absolutelys, yeses. I don't see any no's.
Oh, good. Yeah, good. So that, I agree completely. Yeah, this is definitely, to me, there's no question this satisfies that 4-part test. So good work on that. That was a little review of what we covered on day 1. My second question is, what are the strengths of the plaintiff's case? If you were the plaintiff's attorney, what would you feel good about in terms of presenting this case in the courtroom to a jury? What do you think are the strengths of the plaintiff's case? What do you think would, sway the jury to give a big award to the plaintiff? Again, you can just type a few words in the chat and Kara will kind of just call out a sample of some of the responses.
Yes,
There's
we
probably
have
a
some
number.
moving in right now. There are quite a few people who noted that the contractor didn't follow proper procedures or they didn't give, good answers, that they were unqualified, that the equipment didn't have the proper reflective or warning for motorists. Um, see here, no lighting on the vehicle, complete lack of knowledge of the MOT requirements on all parties.
Yeah, good point. Very good point.
Let's see here. Sorry, I'm trying to read, and as everyone puts in their ideas, it makes it move.
No
So
worries.
we're good.
I'm sure there's a lot of
um,
things coming in, so no problem.
yeah, we've got a lot of really great answers. Let's see here. The state did a poor job of enforcing the stipulations of the permit.
Okay, good point.
Let's see here. They self-admitted to ignoring um, the requirements. Yeah, they talked about the gravel where people, they didn't put down the gravel like they had been required to put down to begin with. The warning, no warning. So yeah, a lot of people are really hitting on those major things about the contractor um, being ignorant to MOT and the fact that there wasn't any type of um, signs or warnings, signage, that kind of thing, that there was something going on ahead.
Yeah, great responses and some really good responses in there. Some things people observed. So I appreciate your good thought and answers to those questions. I have one more question before we get kind of to the jury thing, and that is, if you were the plaintiff's attorney, what things would you kind of worry about maybe the night before trial? What are the weaknesses of the plaintiff's case? And again, you can just put a few words in the chat and Kara will call out kind of a sampling of the responses. But what do you think are the weaknesses in the plaintiff's case?
That's a great question. Let's see here.
And I know most of you are road agency people, but here we're asking you to kind of put on the other hat for the plaintiff side. And what do you think would be the weaknesses?
Play a little devil's advocate. Let's see here.
Exactly.
Midday time. So there was good lighting. The rider should have slowed down and proceeded with caution. Putting the responsibility on the motorist to watch the road ahead. The difference between the speed limit versus the actual speed that the motorcycle was going. They're saying that maybe the motorcyclist should have been kind of thinking about the fact that something could have been going on since the dust was kicked up.
Yeah, I agree. Good point.
Mm.
Those are good responses. Yeah,
Yeah.
thanks, Aaron. Thanks everybody for those great responses. So I know we're kind of in a very formal setting here with the GoToWebinar platform. If we were meeting in person, I might break you up into groups and act like groups of jurors. We can't do that here, but if you could just put your responses in the chat, Carol will again call out some of the interesting ones. But now I'd like you to think about responsibility. So if you were a juror, how would you proportion responsibility among the parties? And remember, the parties are the plaintiff. The plaintiff might be responsible, or fully or partially. The energy company, the contractor, and the state DOT, those are the defendants. And that responsibility needs to add up to 100%. And just one other thing and then I'll let you think about it. But in this state, this is a comparative negligence state. If you recall, we talked about that on day one. So if you find that the plaintiff is more than 50% responsible, the plaintiff does not collect anything. So just keep that in mind in your thinking. So how would you proportion responsibility among the parties if you were a juror here in this, sitting in the courtroom listening to this case, and now you're deliberating? And you can just put like 4 numbers separated by spaces, or put commas between your responses, whatever most convenient to put into the chat.
All right, let's see what we've got here. We've got 5, 10, 66, 20. We've got 50-50 between the contractor and the state DOT. We've got 10, 40, 40, 10. 33.33% for each defendant. Oh, I think they had more thought for that. I don't see the rest of it. 50-50. We've got someone that has 0, 45, 45, and 10. Plaintiff 25%, contractor 75%. 0 for the energy company. We've got someone that feels 5, 60, 20, and 15. So lots of different opinions.
Yeah. But it seems to be what, maybe 10 to 15% the plaintiff, and then 40, 40, and maybe 5 or 10, 40 on the contractor, 40 on the energy company maybe, and then 5 or 10% on the DOT. So it's interesting. I teach this course all over the country, and I do this example, and it's interesting how the percentages are. I know there's some variation here, but the percentages always seem to be close to those values. So it's interesting. And of course, I don't say this in a negative way, but you all, to me, would be a biased jury, because everybody here is probably with a public agency or with a private sector agency. And so we would tend probably more to favor or be supportive of the road agency. But anyway, I think those results are interesting. So thank you, and thank you, Kara, for calling those out. But now I can share with you what actually happened, and there's some interesting twists in this case. Early on, or I shouldn't say early on, actually just before trial, the state DOT made a motion for summary judgment, and their argument to the judge was, we're not an enforcement agency. We issue the driveway permits, but we do not enforce them. And to me, surprisingly, the judge granted the motion, so the state was dismissed from the case. So the remaining 2 defendants reached an out-of-court settlement. Literally, you may have heard the term, sometimes cases settle on the courthouse steps, at least attorneys say that. And this was one of those cases. The trial was ready to start in the afternoon, and the morning of the trial in the courthouse, the case settled. But what interesting twist, and that's why I always say in these things, a lot of it depends on the circumstances and the people involved and so forth. But in this case, the police officer who investigated this crash was kind of incensed by what happened. And I read a lot of police reports in my work. I know many of you do as well. And of course, the investigating officer almost always writes the report in a very neutral fashion, giving maybe the speed of the vehicle and the direction it was traveling, and it struck the other vehicle at the left rear quarter panel, or whatever it might be. But this police report was not sort of neutral. There were comments in the police report that unbelievably there were no signs or warnings about this piece of equipment in the roadway. And so about 2 weeks after this crash, apparently it was still kind of, I don't know, this guy, the police officer, was still upset by this. So he went to the local district attorney, the prosecuting attorney, and explained the situation. And the trooper recommended that criminal charges be filed against the skid steer operator. The prosecuting attorney in the county also agreed, and so he brought criminal charges against the skid steer operator. It went to a jury trial, and the jury found him guilty of, I forget the exact charges, but basically, it was a criminal charge. And so the skid steer operator actually spent 6 months in jail. So recall on day one, I mentioned that tort is not a crime, and a tort is not a crime. It's a civil lawsuit. But in some cases, there may be a crime associated with a tort. And so that's what happened here.
Ron, we do have a question from someone who is curious about the rules regarding grass cuttings being blown into the roadway, maybe by a road maintenance crew or something along those lines.
Yeah, that's a good question. And I think there may, I've not personally been involved in one, but I believe there are, there can be and have been suits involving that, whether it related to, I don't know, harm or injury or damage to property like a vehicle, or cause the vehicle to lose control or something, or also just maybe having, thick vegetation that's been cut. Maybe that was wet or something that accumulates on the roadway and may affect the friction, may cause a slip resistance problem or a sliding problem. So I don't have personal knowledge to share, but I am aware that there have been cases involving that in the past. And so that is something probably that mowing crews should be aware of. Also, one other type of case I think I had early on, related not so much to the actual consequences of the mowing, but the crew had installed in the morning signs indicating that mowing was ahead and the appropriate warning devices. But then as the mowing crew went down the road, and they had gone many miles by lunchtime, they failed to move the warning signs, keeping up with the mowing crew. And so someone alleged, well, I had forgotten that there was warning about the mowing because the signs were many miles in advance of the mowing crew. So I just mentioned that's something else on the mowing operation to be attentive to, is to make sure as the mowing operation proceeds down the roadway, make sure the warning devices follow suit. Interesting question. So what lessons could we learn from this sweeping activity or incident? Of course, and you all know this, anyone working in or near the road needs to understand and follow the applicable maintenance and protection of traffic guidelines. That's the standard of care, the MUTCD or the applicable state manual. And so training is critical for anyone working in or near the roadway, but evidently this contractor maybe didn't even appreciate that they needed training in that regard. And of course, as you all alluded to in your comments, vehicles and equipment operating in the roadway must be equipped with required lights and warnings. And in this case, and the plaintiff certainly would have highlighted this had the case gone to trial, there was a clear violation of state law. The photographs showed that this vehicle did not have a slow-moving, at worst, did not have a slow-moving vehicle emblem mounted on it as well. So this was not a good situation. It's kind of sad. I should tell you a little more maybe about the contractors. They were two brothers, very small company. They actually had grown up and lived in this area where this incident occurred. They were farmers, and so they knew how to operate equipment and so forth. And so when the shale gas started coming to this part of their state, to their credit, they were like entrepreneurs. They said, hey, we know how to operate equipment. We can provide services to these energy companies. We can grade access roads and well pads, and we can sweep the roadway. And so they offered their services. So again, I commend them for that, for kind of their entrepreneurship and their energy. But I guess I would caution, when you're going into sort of work like roadway work, you need to be sure to be aware of what the requirements are in terms of traffic control in the roadway and that sort of thing. And that's where they had a problem. They didn't attempt to do any of that background work. Next case, I call this the offset roadway alignment. Do we need to delineate? Here are the facts, and then I'll show you a little bit about the roadway. This crash occurred at night in October. It was a clear, dry night, so weather wasn't a factor. It's a two-lane, two-way state roadway through farmland. Speed limit is 55 miles per hour, straight level alignment. And the incident occurred just west of a north-south intersecting roadway, where the east-west roadway is offset about 2 feet to the south from what it was on the other side of the intersection. I'm not sure you can see it here. This is a Google image, but it's kind of hard to see. But this is the north-south roadway. This is the road where the crash occurred. This is east of the intersection. And then west of the intersection, which is where it occurred, this alignment is actually about 2 feet to the south of what the alignment is here. And I think you'll maybe be able to see that better on some of the driver perspective images, but this is kind of the overall image. So the crash occurred roughly here, a little bit west of the intersection. Some more facts. The automobile was westbound on the state road, and after it crossed the intersecting road, the vehicle's right tires encountered the unpaved shoulder on the north side of the road. And so when it went off the paved surface into the stone on the north side of the road, the driver steered sharply to the left to try to get back onto the pavement. And so the vehicle crossed the center line into the eastbound lane, and then the driver tried to overcorrect by going back to the right, and that led to loss of control, and the vehicle kind of spun around and eventually struck a tree, large tree. The passenger side struck the tree, and the female passenger who was riding with the operator was fatally injured in the crash. Her family filed suit against the driver and the state DOT. So they were the two defendants. So here's the crash scene. You can see where the impact occurred, and then the vehicle still had some significant speed and energy, so it moved away from the tree, and you see the vehicle at final rest. And remember, the passenger was killed, the driver survived. Amazingly, the driver walked away from the crash just with some bumps and bruises and cuts. So here's a daytime Google view of a westbound driver. The intersection is kind of right in here, but I think you can see, notice it, there's a little jog or offset that occurs at the intersection. And during the daytime, it's pretty visible. The defendant driver argued at night he had no idea, and he had stated he'd never been on this section of road. He had no idea there was that jog in the road. So here's another Google view a little closer to the intersection. Now we can see the north-south road, and I think you can see that little jog or offset there. And here's another Google view. This is the unpaved shoulder where the right tires struck that and then caused the driver to steer sharply to the left. Some investigative findings. The black box in the vehicle indicated that the vehicle speed was 106 miles per hour just before impact. In deposition testimony, the driver, obviously he was asked about why were you going 106 miles an hour on the roadway, and he claimed that a large pickup truck with its high beams on was following him, and he was needing or thought he could get away from that vehicle by going fast. So that's what he did. And if the plaintiff attorney also did some investigation and found an October 2007 Google Street View image, and notice you can see some flexible delineator posts had been installed in this area, but at the time of the crash, those were gone. They'd probably been displaced by traffic or farm equipment or whatever, but at some time in the past, there were flexible post delineators on that north side of the roadway. In the discovery process, the state DOT produced the crash history for this location. And you can see there was, well, little more than probably one crash per year of a similar nature, all westbound vehicles that ran off the road. Interestingly, though, look, most of the crashes did occur during the daytime and during dry weather. So the plaintiff claimed that jog in the road or that offset is unexpected and is deficient roadway design. There should have been some traffic control or cues or delineation to advise motorists of that slight shift in alignment. And as I said, there was evidence that the DOT had previously installed flexible delineator posts, but failed to maintain it. So that was one of the other items in the complaint, was that the state failed to maintain traffic control devices it had installed. And the only delineation the plaintiff said was the white edge line, which there was a white edge line. You may have seen that in the images, but that edge line ended at the intersection. So the plaintiff said that there should have been a dotted extension across that intersecting roadway to provide more continuous guidance for motorists, for westbound motorists. And then finally, their complaint said that it's foreseeable that right tires will end up in the shoulder area on the west side of the intersection. And of course, the state DOT refuted those arguments. But one of the things that was produced during discovery was a maintenance unit work order. Remember, this crash occurred in 2021. This work order is dated December of 2019. And the narrative portion of this work order summary indicates that the crew went out and put shoulder stone down on the shoulder to fill the drop-off along a number of highways. And it goes on to say that the bulk of the material filled in drop-offs where there is a slight jog in the edge of the roadway where the public continuously hits this shoulder, blowing the stone out. This will help the edge of the road and hopefully reduce the risks of accidents. So apparently this maintenance crew had kind of figured out the problem a couple years before the crash. They recognized that the vehicles who failed to make that jog, their right tires were, to use their terms, were blowing out the stone. But it appeared that this information was not shared with the traffic unit or other unit of the DOT. So they claimed they were unaware that there was a problem. In addition to that maintenance work order that I just shared with you, in August of 2021, which would be a couple months before this incident, a local resident complained using the state DOT's website, complained that vehicles were leaving the roadway at this location, and he also noted that reflectors had been present in the past. So the plaintiff argued, in light of that maintenance work order and the fact that delineators had been installed in the past, the DOT was aware or should have been aware of the dangerous condition of the roadway. And the final item of their complaint then was that the DOT was negligent in failing to maintain the positive guidance that they had installed in the past. And there was kind of an interesting twist in this one as well. Well, there were several things, obviously. For one, the driver was almost double, his travel speed was almost double the posted speed limit. Posted speed limit was 55. Driver was, the black box said the vehicle was at 106 miles per hour. So that was the main defense of the state, was that the driver was exceeding, the speed was excessive. They also claimed that they didn't know the location had a crash history, but yet they had produced the actual crash data. And as an engineer, to me, this was kind of an interesting point. They said that installation of delineators at locations like this is an option, not a requirement under the MUTCD, and that's true. Installation of delineation is an option in this instance. So they said that there's no obligation to maintain optional devices. And I guess as a traffic engineer, I guess I sort of take exception to that. To me, it seems if an agency installs devices, they need to maintain them or else have a written documentation of why they're electing not to maintain the devices. But that, the state DOT attorney maintained this was the stance that they were going to take at trial. They were going to try to convince the jury that for optional devices, if they're installed, there's no obligation to maintain them. But this case actually never did make it to the courtroom. The driver's insurance company offered its policy limits just prior to trial. And then a confidential settlement agreement was reached between the plaintiff and the state DOT literally the day before the trial. So I'd be glad to address any comments or answer any questions anyone has on that one. But there, of course, the road agency was trying to put the blame entirely on the driver, that 100-mile-an-hour travel speed is, way excessive, and the driver should have been totally responsible for the crash. But I think that notice, that maintenance work order, I think that was not helpful for the state, nor was the fact that they had installed delineation in the past and failed to maintain it.
All right, Ron, we do have a few things coming in. Someone mentioned that there should be a roundabout there.
That's a great idea. I'm a fan of roundabout. That's a great idea. I like, yeah, excellent idea.
Yeah.
Yeah.
Agreed. Another one, a person asked, did the DOT reinstall the reflectors?
Actually, yes, they did. So that's a good comment or a good question. So there was a subsequent, well, I guess you call it a subsequent remedial measure, but they had been there before, they just were not maintained. But yes, they did put new ones up after the crash. And I think after the lawsuit.
Mhm.
Good point.
Yes, agreed. I am not seeing anything come in just yet.
Okay.
Just a heads up, when we get closer to the end, we do have a question that pertained to the last case study that I wanted to come back to,
Okay.
if
That's
that's
fine.
okay.
Yeah, I think we have like 15 minutes left. I think I have a short one and then a longer one, but we'll try to get through both of these. So lessons learned on this one, units within an agency, I think need to communicate. I think the maintenance unit should have, they were aware there was an issue, a safety issue. They should have shared that information with the traffic folks. And of course, it's important to monitor crash data to identify high crash locations. Regular maintenance and inspections are important. And as I mentioned earlier, if an agency decides to stop maintaining an optional device that they've installed, in my opinion, there should be a written justification of why they're no longer maintaining it. I think to me, it would have looked bad to the jury that they just sort of stopped maintaining it for no particular reason. But maybe there's a good reason, and that should be documented and be part of the file. This is a case I call the accessible crosswalk. We talked today about ADA suits versus tort claims. This was actually a tort claim, but ADA issues entered into it. This was a trip and fall incident, so this didn't involve motor vehicles. Trip and fall incident in a marked crosswalk on a rainy night. A 58-year-old woman who was walking at night with a friend in the direction that you'll see in the photograph, tripped on the angle iron feet of a type 3 barricade and sustained a severe and permanent arm injury. She was no longer able to use her right arm. She was a nurse, and so obviously that affected her earning potential for the rest of her career. And so she filed tort claims against the municipality, the general contractor, and the traffic control device subcontractor, alleging negligent placement of the type 3 barricades, which created a hazard for pedestrians. We don't have any images from the night in question. This photo was taken a few days later, so we don't know if it exactly represents what that crosswalk looked like on the night of the incident, but it's probably pretty close. You can see the feet, these are angle iron feet, and they extend a good distance into the marked crosswalk. And in fact, some of the feet actually have sandbags to weigh them down. What was going on here was, you can see a side street here, and all of this is in the downtown business district of this city. This side street here is closed, obviously, with the barricades for some streetscape work, and also the sidewalk was closed. The traffic control device subcontractor placed the type 3 barricades, or his crew placed them, and he said the crew placed them back behind the stop line because he said he had been to training and he knew that the feet of type 3 barricades, this was his testimony, could be a tripping hazard. So his crews always placed the barricades outside of the crosswalk, or in this case, he said behind the stop line. But also apparently this roadway, which is closed to public traffic, this roadway apparently was the access to the construction trailer and so forth. And so there were contractor vehicles moving in and out of here. And the traffic barrier subcontractor said the contractor would move these devices back and forth and would not pay attention to where they were placing the barricade. So that's testimony. You can take that for what it's worth. But what was the defense of the case? The defendants argued that the crosswalk provided more than 3 feet of width, and so the crosswalk was accessible. It complied with ADA. That's debatable, but that was their claim. And they also argued that if a walkway is accessible, it's also safe. And I think I talked about this earlier in the week. ADA is an accessibility criteria. It's not a safety criteria. It's still up to us to make sure we build safety into these locations or into these projects. But that was the defendant's stance in this case. And they also said, had these women walked in a single file, the incident would not have happened. And I guess my sort of thought on that is, well, if multiple people are walking, friends or family, who walks single file? You like to walk side by side so you can interact and socialize with the people you're walking with. But that was their defense. The plaintiff argued that the barricades should have been kept moved back, assuming they were installed properly originally, so that they were out of the crosswalk. Or the plaintiff also, this is not the same location, it's a different site, but the plaintiff also said use a different type of barricade and support mechanism. Here you can see the type 3 barricade is attached to a channelizer, and so there's no feet that project into the walkway. Confidential out-of-court settlement was reached here just before trial. So what can we learn from this? Just because a facility is accessible doesn't necessarily mean it's safe. Details are important and probably should have been shown on the construction plans of where those type 3 barricades were to be located. It was left up to the construction personnel. Communication between the parties is essential. Apparently the barrier contractor and the general contractor really didn't communicate about the location of those type 3 barricades. And training is important. Apparently many of the contractors' personnel involved in this project had no training in either temporary traffic control or pro-ag. So any questions on that one? If not, I'm going to probably speed up the next one here. But I did want to get this in, and I do want to leave the end for a question. Questions coming in?
Nope, no questions.
Okay. I call this the hazard tree case, and I'll probably go through it a little quickly, but envision this was a large oak tree, estimated to be like 300 to 400 years old, 30 feet off the road and 20 feet up on a steep bank. And one Sunday morning, it just fell onto a car carrying 5 people. And as you'll see from the photo, it's kind of uncanny. It just fell right on the rear seat portion of the vehicle, killing the occupants, who were all older than 90 years old. So in some of these other cases, I've talked about lost wages and lost earnings. That's not an issue in this case. This is a media photo of the tree that after it's been cut up, so the emergency responders could get to the victims. Here you can see, notice the rear of the vehicle and the front are not really damaged. The roof has been removed by the first responders. The driver and the front seat passenger were injured, but not fatally injured. So this was a triple fatality. This is the remains of a tree in the resident's yard. There were 3 lawsuits filed against the road agency alleging negligent maintenance and inspection of the roadway and for failing to identify and remove the hazard tree. A lot of information was generated. One complication was the day after this crash, the road supervisor was quoted in the newspaper as saying this tree was 30 feet off the road and therefore was outside the right-of-way. It was the property owner's responsibility. But during discovery, it came to light that 30 years before this crash, the road agency had purchased 50 additional feet of right-of-way to provide sight lines for a new intersection. So actually, this tree was in the road right-of-way. And I'm going to skip through some of these a little quickly here. The tree, of course, is gone, but it was probably up here in this location, fairly high up on a very steep slope. A resident who lived across the street said he never noticed a health issue with the tree. There you can see the slope is pretty steep. There were some local residents that testified that the tree was dead for years, so we had conflicting witness testimony. The plaintiff hired a forestry expert, and this is not the tree in question, of course. This is another tree up on the slope. But if you look closely, you can see some fungus or mushrooms or conchs, I guess the foresters call those. And the forestry expert claimed when he examined the tree that fell, he observed conchs on that tree, and that was an indicator of a health problem. And in his opinion, he said that meant the tree should have been taken down immediately. And furthermore, he said, and this seemed a little bit out of the realm of reality for me, but he said that the fungus mushrooms on that tree should have been identified during a normal drive-by inspection. And remember, this is 20 feet up on a slope in a wooded, brushy area. So I'm not sure it's reasonable to think that a road agency employee would have identified that. But this settled out of court prior to trial. Lessons learned, big one is know your facts before you make public statements. So this road supervisor talked about the right-of-way, but it turned out he was incorrect, and that would have not looked good in the courtroom. And my opinion is crews need to be on the lookout for things like dead limbs over the roadway, trees leaning toward the roadway, holes in trees, other characteristics of, quote, hazard trees. But I'm not sure it was reasonable in this case to expect a road employee to identify these conchs or mushrooms 20 feet up on a slope and off the roadway. So I think I'll stop there. I'd be glad to answer any questions on this or to address the question that Kara raised or is going to raise.
Wonderful. Thank you, Ron. Okay, so we have two questions that have come in. One of them, they're from two different case studies that you did. So the first question is asking, could the road agency be held liable if they specifically directed a contractor to sweep a roadway and the contractor does it unsafely?
Let me put it this way. I think certainly both parties would be named in a suit, in a lawsuit or in a tort claim. It would be up to probably a jury to assess the facts to determine the degree of responsibility of the road agency in that scenario that was posed. So yeah, I'm concerned that there would be exposure to a tort claim. How that would resolve itself either in the courtroom or prior to trial would probably depend on the specific facts and what sort of a case the road agency could present in their defense.
Wonderful, thank you. And the other question, the person was trying to understand why the DOT wouldn't have widened the edge of the road to eliminate the 2-inch offset. They're wondering if you know if maybe they had a lack of right of way, or if you have any inside information as to what was going on with that.
That is a great question, and actually I asked that question myself because about 4 years before this crash, they did resurface that east-west roadway, and my thought was that would have been a good time to maybe widen it or put in a taper or something rather than that abrupt jog. And I believe that question was asked of the DOT employees, and they all claim not to have any knowledge of being involved in that kind of that paving project or developing the plans for that paving project. So that's an excellent question, but I'm afraid I don't have the answer. it may be that they just, I don't mean to be harsh to them, but it may be that they just didn't really think about safety in that resurfacing project, or maybe kind of the roadside safety issue. But I wish I had a better answer for you.
No, thank you. Just something for everyone to think about, huh?
Yeah.
All right. Well, um, let's see here. We do not have any more questions. So I'm going to go ahead and say that on behalf of the Ohio LTAP Center and ODOT, I would like to give a huge thank you to Ron for sharing his expertise with us over these last 3 days. It's been incredibly valuable. A couple of final reminders as we sign off. Keep an eye on your inbox, everyone. We will be sending out a link to the session recording to all registered attendees very soon, as well as PDF. And as we close out, there's going to be a super short 4-question survey that'll pop up in your browser. If you have 60 seconds, please share your thoughts with us. It really helps us fine tune these programs for you. Thank you all so much for sticking with us through day 3. We hope you're walking away with some great insights for your work. Have a fantastic rest of your day, and we'll see you at the next one.
Yeah, thank you, Kara. Thanks everyone for participating. Hope you found this helpful. Thanks for your great input, and look forward to seeing folks at future LTAP training. Thank you.
Thank you, Ron. Bye-bye, everyone.